Councilman approach on state versus illicit drinking.
Good afternoon. Need to talk to you.
Are you going to do another one?
Yes, I'll do one right now. State versus Abraham Gutro Jr. Mr. Gutro, come to the table right here, please. State. Mr. Gutro, we're here because the county attorney's office has filed a Class A felony complaint against you. I understand that you do not want to be represented by an attorney in this matter.
Yeah.
And that you haven't filled out an application.
Yeah.
Is that true?
Yes, Your Honor.
Let me give you some information then. Everything in this proceeding is recorded. You're charged with an offense that's punishable by up to 7.5 to 15 years at the New Hampshire State Prison. It's one of the more serious felonies that you can be charged with. If you can't afford a lawyer, I'll appoint one to represent you at no initial cost. I may have to reimburse the state at some point, but it wouldn't cost you anything for me to appoint an attorney to represent you. The hearing we're here for today is your arraignment, which is your first time in court. And I know that there is an affidavit on file prepared by, looks like Troy Police Department, kind of outlining what the officer thinks occurred. Now, I'm going to enter a plea of not guilty on your behalf at this point, but I'd strongly encourage you to think about applying for an attorney. Because this is a serious matter. I don't know anything about you, I don't know anything about your record, I don't want you to say anything, because anything you say can be used against you. I mean, it's possible for you to go to jail for a very long time on this offense. So I'm going to enter a plea of not guilty on your behalf. I wouldn't accept a guilty plea, even if you wanted to enter one today, without you having been represented or consulting with a lawyer. The next thing I have to do is take up the issue of bail. What's the state's position? The bail commissioner already set bail at $2,500 PR. Are there any changes?
I'm not seeking any cash bail, Your Honor. I'm seeking a pure bail. I'm just going to look at the order. The only changes I would ask for is that the court required to execute a waiver of extradition, and also I would ask for a condition that he not be on Mr. Lanson's property. Aside from that, I can get approach. May I approach with the proposal?
Yes, please.
Thank you. And I have a copy for Mr. Gutro. That's what I'm saying.
Okay, thank you. All right, Mr. Gutro, is it your intention to apply for a court-appointed lawyer? I'll tell you what. Why don't we do this? Why don't you at least submit a request for one? I can appoint one to you, and you can meet with somebody, and then if you decide after that you don't want a lawyer, you can just let me know, and I'll remove the attorney. But there's really no downside for me to appoint one to you at this point. Do you agree with that?
Yeah, I agree, Your Honor.
All right. I mean, it's a serious thing. You seem like a young guy. You may be in way over your head on this, and you have nothing to lose by filling out an application and having me appoint one for you, and at least see what that lawyer has to say about the case. You understand?
Yeah.
Okay. So what I'm going to do is you're going to have to fill out an application. Okay, you have to do it in writing. Do that before you leave. You're going to go to the clerk's office, fill out a form, and just fill it out. It asks you for your financial status. I'm assuming that you're going to qualify. And then I'll approve it, and we'll appoint a lawyer to represent you very quickly. The state's requesting that bail be continued as was previously set by the bail commissioner, but that you can't go on Mr. Lanson's property. I'm going to keep bail at $2,500 PR so he doesn't have to execute a new bond. And within 30 days of having your lawyer meet with you and contact you, have your lawyer review a waiver of extradition. I'm not going to require it right now. We give you time to talk to a lawyer first so you know what that means.
Okay.
Do you understand?
Yeah.
Okay. Other conditions are the same pending trial that the bail commissioner already reviewed with you, which means you can't possess a firearm, destructive device, dangerous weapon, or any ammunition. No use of alcohol or controlled drugs as defined by the New Hampshire law. No contact with Mr. Lanson or go on his property. And the waiver is going to be due within 30 days of appointment of counsel. Okay, so I'm gonna direct you to go over to clerk's office right now, fill out an application. Did they just give one to you, actually?
No, I gave him a copy.
Okay, do we have an application for the court counsel over there? The financial affidavit. Yeah, I figured we would. Really important, Mr. Gudo, to make sure your contact information on that form is accurate, so that that's where you receive mail, and your cell phone number so that your lawyer can get in touch with you. You understand? Okay, so fill up that form and leave it with the clerk's office. It's right down the hall over here before you leave the courthouse. Do you understand?
Absolutely.
Okay. Thank you both. Okay, State versus Jared Fellows. Yes, please. Thank you. Okay, we're here in the matter of State of New Hampshire versus Jared Fellows. Good afternoon, Mr. Fellows. I think we were originally scheduled for this morning, but there was an issue, transportation, so we rescheduled for this afternoon. It appears that you reached a fully negotiated plea agreement with the State of New Hampshire to resolve your pending Class B felony burglary complaint. Is that right?
Yes.
Okay. And it appears that the agreement that you've worked out with the State of New Hampshire is that in exchange for your plea of guilty and admitting to the charge, that you be sentenced to the state prison for not more than 4 years nor less than 2 years, stand committed, and that you're given pretrial confinement credit of 279 days. Other conditions of the sentence are that you are ordered to make restitution of $5,205.98. Ms. Paula Ross, did her husband sustain any loss, or is that the total?
That's where the insurance didn't pay and some money was recovered, so that's the outstanding loss.
Okay, all right. And you're going to have to pay that restitution through your parole officer when you're released. You understand that?
Yes.
Okay. Also, the sentence, and that makes you eligible to receive earned time credit while at the state prison if you complete any programming up there. There's a waiver of sentence review requirement on the sentence, and you have to remain on good behavior. You understand that?
Yes.
Has property been returned and or disposed of already?
What was, I believe, has been returned.
Okay. Now we'll get to whether I think that's fair and some victim impact in a second, but let me review this acknowledgement waiver of rights first. I have this acknowledgement here. It looks like you signed it just now. You completed 12th grade. Is that right, sir?
Yes.
Is that your signature on the form?
Yes, sir.
You understand that you don't have to plead guilty today, but by doing so, you're waiving all these rights?
Yes.
Did you have any problem reading or understanding any of these rights?
No.
You understand that by pleading guilty, you're waiving your right to a speedy and public trial by a jury of your peers. You understand that?
Yes.
You're also waiving your right to have your attorney continue to defend you, cross-examine any witnesses, call any witnesses that might be favorable to you. You understand that?
Yes.
And waiving your right to have me order and record evidence and witnesses that might be favorable to you, right?
Yes.
You're also waiving your right not to be convicted of this offense unless and until the state proves your guilt beyond a reasonable doubt. You understand?
Yes.
You understand what the state would have to prove in order to convict you of this burglary offense?
Yes.
That you entered the dwelling or an occupied structure, which was in a residence, and you weren't privileged to do so, and you had the intent to commit a crime once you were in?
Yes.
Okay. Do you have any questions about any of the other rights in this form that I haven't specifically reviewed with you?
No.
Other than this plea agreement, has anyone made any threats or promises in order to get you to plead guilty here today?
No.
Are you doing so freely and voluntarily?
Yes.
Did you take any drugs or alcohol before coming to court that would affect your ability to understand these rights to the consequences of your plea?
No.
Attorney Parsons, have you noticed anything in your interaction with your client today that would cause concern about Mr. Fellow's ability to execute a knowing, intelligent, and voluntary waiver of his rights?
No.
Okay, I've reviewed the affidavit submitted by Trooper Byrne, I believe. I'll find it establishes a sufficient factual basis to justify your plea and that your waiver of rights is knowing, intelligently, and voluntarily entered. If you please stand, sir, I'll take your plea now. To the Class B felony burglary on June 5th, 2017. How do you plead to that offense? Are you guilty or not guilty?
Guilty.
A finding of guilty is entered. I'll find your plea of guilty is free of any coercion and is the result of a knowing, intelligent, voluntary decision on your part. Why don't you have a seat? I'll hear from the state on the justification for its sentence.
Thank you, Your Honor. Mr. Fellows taking responsibility for this crime here. I misspoke on the property. It was seized in another county, so this will allow to be released out there. He was a suspect in a burglary in another county, and a search warrant at his residence. Some of the property from this burglary was found there.
Mm-hmm.
So,
Is it Sullivan?
I believe it was Merrimack.
Merrimack, okay.
And there's some other outstanding burglary charges, I believe, in Hillsborough County, which are not addressed by this.
Mm-hmm.
He has a prior trip to state prison. The Merrimack charges ended up in a total of 4 to 8, Your Honor. This sentence is essentially going to be concurrent with that. Take responsibility for this. I believe it's an appropriate sentence. The victim here, in fact, walked in on her, in her residence, so.
They were coming back from the grocery store.
Exactly. She would like to address the court, Your Honor, and give it back to the.
Okay. Ms. Ross? Hello, Ms. Ross.
Hello there.
Give me a second to set the microphone.
Okay. June 5th, 2017, at 2:30 p.m. will be a date and time we will never forget. That is when the idyllic time in our cottage was violated by Jared Fellows, entering the residence by force. I had just returned home from a day of running errands to come home to find the front door kicked in, although the deadbolt held. Then looking in through the door panes while I was trying to get my phone out, I could see him exiting through the side porch door, which he had forcefully opened. I confronted him on the porch as that was the only way out. I asked him what he was doing there. He said he was asking for directions, and I screamed at him and told him to get out in my best grandmotherly voice. The family cottage, or as we call it, camp, has been in the family for 76 years. This has always been a place of refuge and tranquility for 4 generations. It is our own golden pond. No matter what was going on in your life, you could always go to camp and chill out and enjoy good times with the family, swimming, fishing, kayaking, boating, and just plain relaxing on the porch. This piece was shattered on June 5th, 2017. He entered our cottage and proceeded to violate our space. All of our jewelry was taken, and we could tell he had rummaged through every drawer in the dressers upstairs and through our clothing, including the dirty clothes. A vintage Monopoly game was left on one of the beds, but the tokens were gone. The jewelry he took consisted of various everyday items such as earrings, watches, and necklaces. But he also took more valuable items with very special meanings and significance. My diamond engagement ring. Back in the 70s, I had lost this stone out of my original engagement ring. And finally, in 2001, for my 50th birthday, after raising 2 children and getting them to college, my husband was able to replace that ring. Now it is gone. There was a vintage diamond ring that belonged to one of my aunts. That was probably 80 years old. And that was something I was hoping to pass down to one of my granddaughters. Now that is gone. I had a mother's ring consisting of a pearl, ruby, and amethyst stone, which I received from my husband and children for Mother's Day probably about 25 years ago. Now that is gone. Pearl earrings with diamonds and matching necklace given to me by my daughter in 2004 when she got married, that's gone. A pearl and diamond ring and pearl bracelet given to me by my son in 2004 when he got married, that's also gone. There was a black Tahitian curled cultured pearl necklace and matching earrings given to me by my husband in 2005, also gone. My original engagement ring with a stone out, which was given to me in 1973 by my husband, that's also gone. A Pandora bracelet with many charms given to me by my children and granddaughters in 2011 for my 60th birthday. Each charm has a story, the birthstones of my granddaughters, charms from them for Christmas, charms for a special trip we went on, all gone. Our plans for the summer changed as a result of this violation of our privacy and space. We felt we were no longer secure there. Plans to have our granddaughters from Iowa come visit had to be changed. Since it took some time to replace the 2 damaged doors, we did not feel it was a safe place for them. We were not sure if he was not going to return. We did have our granddaughters that live here in New Hampshire come visit, and they saw the damage he did. This made an impression on them as well. My granddaughters now hide some of their treasures, so the bad man won't come and take them. They should not have to feel that way. As they said, he was rude to break in and take our stuff. Since our burglary on June 5th, Mr. Fellows continued to rob other individuals and turn their lives upside down.
He was arrested and released on bail for a robbery in Francistown in July. He was finally arrested August 27th for our burglary. He spent 3 days in jail and then was released on bail on August 31st. On September 2nd, he is attending the annual picnic of the Arch Church held at Clough State Park, as seen on their Facebook page. Apparently, the religion did not help him. On September 6th, he is caught on a surveillance camera for a burglary in Concord. We feel he should get the maximum sentence allowed for this case. Hopefully, he will be successfully prosecuted for the other charges and will spend a long time in prison. Perhaps then he can find true religion and be able to contemplate his misdeeds and ask for forgiveness. His Facebook page lends one to think he believes in Jesus, but his deeds do not reflect that. He should study the commandments, especially number 8, thou shalt not steal. I do want to thank Anna and Trooper Bird. He was, they both were very instrumental in making this a terrible situation worth, at least tolerable. Thank you, sir.
Thank you, Mr. Ross.
Now, the person was arrested. In these cases, it's never the amount of money that's gone, it's the personal things that are passed. So what is taken into account today was the speaking of mental report, as well as, well, it's not explicitly a global offer. There were some issues with the Merrimack case that he has pled to in anticipation of this plea. So they are tied together, at least to that extent. So for those purposes, we urge that the court accept the plea as offered.
So the total amount, essentially, that he'll be serving under the sentences that he's currently serving, including this one, will be about 48 years?
It is 48 plus the ounce, whatever happening in Hillsborough, which is not associated with this, or American Return. So it's at least 48.
Which is actually more than the maximum.
Correct.
Okay, thank you. Attorney Parsons?
I have nothing to present to the court unless the court has questions. There is some difficult childhood background that Jerry would prefer that I not discuss in this case.
Does your client wish to say anything? Mr. Fellows, I don't know much about you. Please stand, sir. And I don't know if you could hear what Mrs. Ross said. I honestly don't know. But I hope you did. I hope you have some empathy. And the little trinkets that you stole from their dressers were not just trinkets. They were significant parts of that family's life and that family's legacy. And when you, like the state said, when you take those types of things, you don't just steal a ring. You steal a memory, you steal an event, you steal part of their past and part of their future, and it's a lasting effect. I can't tell whether or not that means much to you. The sentences that you're serving for the spate of burglaries that you committed, that seems to be in a short period of time, you're going to be serving more than 4 to 8 years in the state prison. Possibly more based on other charge conduct in other counties that I don't have any control over. But I think based on what I have before me here, that this is an appropriate sentence. And that's the sentence I'm going to adopt that is recommended by the state. So you're sentenced in accordance with the plea agreement to 4 years at the state prison, eligible for parole after 2, with the pretrial confinement credit of 279 days. Obviously, there's no tie-in to this sentence to what might happen to other unresolved charges. Wish you the best of luck, sir. Thank you. Thank you.
Thank you.
Thank you, Mrs. Ross.
Thank you, sir.
Customer approach on Brian Bushy. Just stay on the record, but you can approach. Okay, we were scheduled well, not really even scheduled yesterday. He was apprehended but too sick. So just to put it on for today. There are a couple of warrants that are keeping him tied up. One for failure to appear for drug court, the other is for a new burglary. And then today, the sheriff's indicated to me that he just, well, I guess the message I got was he just didn't want to come to court. That he was physically able to, he just didn't want to come. And I know you were appointed to represent him on the new burglary charge, right, Attorney Franklin?
I don't know, almost,
I think I did, okay. So I'm just going to enter a plea of not guilty on his behalf. And pending further request for bail, I'm going to just order that he be detained on a probation violation. Okay. Any objections to that, by the state? Okay. That's okay. I got it right there, it's all right. Just said 10,000 cash. With the standard conditions posted. And we'll set that probation violation sometime in the future. Do you have discovery done on the burglary yet? Do you have it yet?
I have some of that.
Okay, all right. I don't know anything about it other than what's in this file, so.
Your Honor, just so the court is aware, I plan to file supplemental DOP based on the burglary allegation.
Okay. We'll schedule a separate arraignment for that. We don't do that. We'll just combine it whenever we schedule the hearing and take. So, okay. You've been out to see me? All right. I understand. My sense is he doesn't want to see me. Okay, thank you.
Thank you.
Steve versus Candace Garcia. Good afternoon. Okay. Hello, Ms. Garcia. We're here for a review hearing. See how you're doing in behavioral health court. Where are we, folks?
So, Your Honor, and I'll sort of give an overview, and then I'll give however much history or detail you would like, as I'm sure Judy will too. But essentially,
Everybody can sit down except for Attorney Legault. Go ahead.
So Candace has been in the program since March. If the court recalls, we were here last October for sentencing. Although she was made eligible for both EM and work release and actually determined to qualify for EM, and I don't have a great sense of what occurred, but my understanding is that there was a conflict with another inmate. As a result, Candace was sent to serve the remainder of her sentence actually up in Sullivan County.
Okay.
And Sullivan County doesn't really have they don't have an EM program, I don't believe. And they certainly don't have as robust a work release program as Cheshire. So essentially, Candace served the full 8 months, got out, started behavioral health court with Judy, had some difficulties with housing, with insurance. Long story short, has been, I think it's fair to say, struggling, but remaining in the program, connected with Judy. She is presently a client or patient, I guess I should say, at Keene Metro. And the plan is to refer her into IOP. Candace is aware of that plan, is on board with the plan.
How long has she been out?
Out since March.
Okay, all right. So this is the, okay, the first of the quarterly reviews then.
Yes, and I do think everybody's in agreement, Your Honor, that it makes sense to come back for review in September. I think it makes sense to check in significantly sooner to see how she's doing, so that if she's not doing well, it can be addressed more quickly, or if she hopefully is doing well, and if we come back early September, ideally she'll be substantially through, or at least have a pretty decent start on IOP at that point, if she's able to get in quickly.
What's behavioral health court's position on that? How's she doing?
Yes, she has, throughout her time, had some treatment attempts. She had set up something in Massachusetts, a hospitalization program. Things fell through with that because of housing, because the insurance got transferred over to Massachusetts. She stayed in contact with me on the phone. She came back, got herself into the Rapper retreat for detox, started a Suboxone program. That was
When did she start MAT? When?
That was back in May.
Okay.
Right, because it was April that she was attempting the Massachusetts and was going to be seeing a doctor for that. Over there, everything was not working out.
Okay.
Came back, so right in May, she started Suboxone, which wasn't working very well. So then she switched over to methadone at the Metro Clinic. Meanwhile, we've been checking in about possible inpatient treatment, IOP, kind of looking at treatment options, having transportation issues, talking about getting back into meetings. I've had her way back in the past where she did really well in our program, just doing AA meetings. She was doing 2 or 3 a day with the sponsor, so we have that history. So it was kind of working with her on that, referred her to an individual therapist for unfortunately transportation issues. Metro Clinic, she's been there for a month and is still not completely stabilized, so recommending IOP. Not recommending individual therapy at this point because she has plans to move to Florida at some point with her mother and her son and daughter, and it doesn't make sense to get engaged with an individual therapist at this point now. But she
What's her housing situation, do you know?
She's living with her father.
Okay. Does she have custody of her kids?
No. She's also definitely addressed other needs that she has, some mental health needs, and that's definitely addressed, and she's doing well with that. So anyways, at this point, and she does show up, she's completely upfront and honest, and I think IOP will help her being successful.
State?
Thank you, Your Honor. The state recommends that she remain in the behavioral health program, and as the defense counsel indicated, we would ask for a review here in September. The suspended probation ends, that window ends in October, so we'd like to visit this one more time in September.
Yeah, Lugo, does your client have anything she'd like to say? She seems a little nervous.
I know she was concerned. I mean, Candace is, all her children are in Florida with her mother. And so her hope is to get to Florida sort of eventually / sooner rather than later. But I think she also recognizes that she wants to make sure that she goes down there in a stable place so that then she can hopefully get off to a good start there and maintain sobriety and doing well. Do you want to say?
Okay. We'll schedule a review in September. The clerk will issue a notice. What's the address? It's her father that she's living with?
Yes.
Is that local, or I hear
It's
transport?
in 5 minutes, not Highway. My understanding is she now has her vehicle back.
I do.
Yes.
Yeah, I just got my vehicle back on the road, so I started my AA meetings again this week.
Well, they're steering you towards IOP, so
Yeah.
get into that. You could be pretty much complete with IOP by September, the next time you see me, you'll be well on your way to hopefully reuniting with your kids in Florida.
Yeah.
Okay?
Thank you, Your Honor.
All right, thank you. Melissa Robinson next. State versus Melissa Robinson.
You're still on the church's
I have no doubt that you two have reached an agreement, right, on sentence? Two reasonable lawyers? No?
I don't do that for a lot
Theoretically, no.
Okay. Okay, we're here in the matter of State of New Hampshire versus Melissa Robinson. We had a probation violation hearing back in early June 7th. It was a contested hearing. I issued an order, a written order, June 19, 2018, finding the state had sustained its burden in proving a violation of probation in this case and scheduled this for sentencing. Attorney Wells, have you reviewed the order with your client?
I have your Honor.
Okay. So, Ms. Robinson, we're here for the sentencing phase of the violation of probation. So I'll hear from the state first, then I'll hear from your attorney.
The rationale for this case, proposed sentence, which was not more than 5 years but less than 9 months in a state prison with 134 days pre-trial confinement credit, essentially has to do with Ms. Robinson's long history of not appearing and essentially disregarding the obligations of both her sentences and probation. The court may recall on the original charge, which was possession of controlled drug program, private collection in the parking lot. She was arraigned and she failed to show up for a hearing because of physical hearing on that particular case. Was eventually, a warrant was issued, was eventually arrested and spent, I think, 19 days in jail before their case was resolved, and she was placed on probation, and then she had a violation of probation. On the violation of probation, she was given a 180-day sentence with the opportunity to serve most of it on home confinement electronic monitoring. Claremont,
Cut off her neck.
cuts off her neck and everything, and Wisconsin. She then eventually gets arrested on that, and was brought before the court on another violation of probation. That is the time on that, released, and again, we're here again today because she essentially just disregarded her probation officer's instruction to report it to him. In addition to that history, she has a Vermont history which shows some conviction in 2017, which was after she was convicted of the offenses, the drug offenses, 2016 year. Quite honestly, I don't know the conduct that forms the basis for those convictions took place, so I can't say the conduct.
They were drug offenses, if I recall correctly.
No, they're all thefts. Retail thefts.
Okay.
But she also has a history in Vermont. She failed to appear in court in April 2014 and March of 2016. So